as scheduled. And so, Leonie, I give you immediately the floor for your presentation.
Thank you. Thank you very much. I hope you can hear me, Anthony, and everyone in the room.
Yes,
Perfect. Yes. Yeah. Great. I'm an academic, so my take will very nicely build upon what has been discussed before. The keyword experimental regulation has already been mentioned, as well as by Dr. Rauscher, the policy that becomes before the regulation. So these are two thoughts that I will develop in my presentation. And see what the concept of safety sustainable by design can mean, not only for the chemicals sector, but also beyond. Could you please switch to the next slide? I guess the broader framing of the European Green Deal, but also the Circular Economy Action Plan has already been discussed, so I don't need to repeat that. So the paper that we are currently writing tries to answer the question of the benefits of and challenges, the legal ones, of course, that the SSbD concept as a regulatory approach has. To strengthen the EU circular economy. So as I mentioned before, the idea is to look beyond the chemical sector and see whether the concept as such is a regulatory concept that can move us forward in achieving the objectives of the European Green Deal, but also some of the challenges that are inherent to the regulation of emerging technologies generally. Next slide, please. So there's a theoretical discussion connected to this. This might be less relevant for the practitioners in the room, but the SSbD concept poses, in my opinion, or in our opinion, Julia's in my opinion, a very interesting case study on how to, on the one hand, advance some of the problems that generally lawyers deal with when it comes to regulation of new technologies very fundamentally. And at the same time, it also poses challenges that need to be taken into account when SSbD needs to be implemented. So the first theoretical hook, I guess, is what Ronald Lenes distinguishes, first of all, regulation of technology versus regulation by technology. Regulation of technology, I guess that's the classical approach of regulation that we are having, whereby technology is the regulatory target of regulation, and regulation by technology, which is arguably a bit more innovative, is whereby technologies are used to regulate. So SSbD can be an interesting case study of both. Ultimately, it has the aim to regulate technologies by the design, as a part of the name suggests. So you could arguably say that SSbD has the potential of being an example of regulation by technologies. Karen Young, I guess, is the mother of at least the academic regulatory approach of regulation by design, which seeks to pursue collective goals by using technology design to achieve these goals. So regulation by design, in that sense, involves the intentional shaping of the built environment or technology systems to achieve certain regulatory goals. And I think this is characterized by her as a very powerful tool for achieving regulatory objective because it can influence behavior without the need for explicit legal or regulatory interventions, which is very big example taking into the account of some of the problems that I will discuss in a bit. And in this way, design-based control mechanisms are, and I think that has been touched upon in the previous sessions as well already, extremely powerful because they can be enacted ex ante rather than ex post, and in some ways say way, they are also self-executing rather than demanding the attention and interaction of others. Another benefit of the SSbD concept is that it arguably addresses what Easterbrook characterizes as the law of the horse, which he says that not every technology needs a regulatory framework. And we often see that emerging, so that there is specific legislation for, let's say, hydrogen, for nanotechnology, for each technology that it's being developed, and technology that develops very fast currently, but that it should be addressed via existing norms. And we try to see whether SSbD can also be a solution in this regard for the prevent to always come up with a completely new regulatory framework for each new technology. Connected thereto are the pacing problem and the Coleridge dilemma. So this is the question of what point of the regulation of what point of the development of the technology regulation should intervene, especially because, as at least the lawyers in the room know, that always law very much lags behind, and technology always develops faster, and regulation always tries to catch up. So these are potential benefits from a more theoretical perspective that SSbD has. But there are also several challenges associated. I discuss more in a bit, but one remains here is the perceived challenges of regulatory capture. So if we look at how and who and where the concept will be eventually implemented, which is, I guess, at industry level, that means that, there's a problem, could be a problem of regulatory capture, and I guess further research needs to be done on how this can be addressed. So we're not saying that SSbD will address all these problems, but we see that it can serve as a potential tool to enact a flexible yet adequate regulatory tool to enhance safety and sustainability in emerging technologies more broadly than only the chemical sectors, and why it cannot. So it's still ongoing research. We don't come up with a solution here, but we try to highlight the opportunities and the challenges thereof. Next slide, please. Yeah, I guess most of the things on this slide have already been discussed. I just probably should highlight here that safety by design is an application of the precaution and arguably a precaution and the prevention principle, which has a very strong fundamental basis not only in the EU treaties, but in EU secondary law general, also beyond only the chemical sectors. Yet it's a more anthropogenic approach. So traditionally, safety really relates to providing safety for workers, for consumers, for the people that develop and use the technologies or products. So arguably, the sustainability by design aspect broadened the scopes to also include other aspects such as the environmental impacts thereof. And very similar to it is the circular by design approach, which has been used by the European Environmental Agency in their document, at least. Yeah, but I guess the other points have already been discussed, so please move on. Yeah. So as a regulatory approach, how can this be seen? So we say that it's a form of flexible regulation based on precaution and prevention principles. I said before earlier the term experimental regulation has already been used. I think that is a good characteristic to describe this approach as well. So it's a principle-based approach, and some guiding principles are already included in the recommendation and criteria, such as material efficiency, use of renewable energy sources, etc., etc. You know that. What is the key here, I guess, and that has been discussed in the previous sessions on liability, is the role of the designer or innovator of the process, that it's a more active one, also for, from a regulatory perspective. And that leads to the challenge of legitimacy. And you could also arguably also say that it's a privatization of governance. So not the government in the driving seat anymore, but the companies, which actually has questions about liability as well, but these have been discussed. So far, if we could say that, building up what Dr. Rauscher said, that it's policy first and then regulation, it's a complementary to existing safety and sustainability design rules and legislation. And I guess it remains to be seen whether it stays like this or whether it becomes indeed an instance of regulation by technology and not only regulation of technology. Please feel free to change the next slide. Yeah, so these are some examples of how it has been included. I guess we can skip that slide as well. These have been discussed in previous presentations. Yeah, so this is our own compilation of the our understanding of the benefits and challenges or limitations of the SSbD concept. And we diversify. It's non-exhaustive. I have to say that as well. There are arguably more challenges, but these are the ones we thought are the more important ones. So we have grouped them into legal and technical challenges. My co-author has a technical background, so she's more equipped with a technical perspective. So if we start with the legal benefits, from a legal perspective, you could say that the SSbD concept indeed provides for flexible, principle-based regulation in contrast to rigid rule-based regulation. In that sense, legislation is also, or rules are simpler on the one hand, and another benefit that it is that it has a wide scope of application and that it also targets non-regulated emerging technologies. So if we make the bridge to the theoretical framework, so this is indeed a very big target, a very big benefit. Also, as I've already mentioned, it provides for simpler rules and standards that are easier to understand. And you could say that there's also increased compliance with existing rules on SSbD, on safety and sustainability. And on the one hand, as you can see, liability, we didn't know whether it's a benefit or a challenge and limitation. It can, I guess it depends on the argument. It's definitely a big point for attention. So we've grouped it here in the middle. But on the other hand, from the legal perspective, there are also potential challenges and limitations. And I guess these relate mostly to the challenges and limitations that are generally inherent to having a flexible, principle-based approach that overall result in legal uncertainty. One of the first, I will zoom out into 5 of these challenges. The first one is, I guess, that principle-based regulation can lack clarity and specificity of how these principles are actually applied, which increases the difficulties on the one hand of regulators to enforce compliance, but on the other hand also for the regulated entities to demonstrate compliance. And then secondly, you could say that inconsistency could arise because principle-based regulation relies on the judgment and interpretation of everyone, not only judges and regulators, but also compliance persons in companies, technicians, etc. Whereby there's a risk of inconsistent decision making and enforcement, and different regulators and or companies may interpret the same principles very differently, which could lead to various and sometimes even maybe conflicting outcomes. Then the third challenge, that directly relates to uncertainty and ambiguity. Because I guess of the advantage that principles based on integration relies on general principles rather than specific rules. It can be ambitious and lead to legal uncertainties, and that again relates to compliance. And from compliance, the challenge is that it's indeed less prescriptive, so there's more leeway in interpretation. So actually, you could say that is the counter side of the advancement. And accountability poses a challenge because it is rather difficult to hold regulators or indeed the designers accountable for their decisions if these are so rather vague and unprecise. Legitimacy could become an issue as designers are indeed in charge of integrating safety and sustainability by design in the products or processes. Not only the issue of regulatory capture, but also legitimacy, because it's indeed a move rather towards private governance away from governance by the regulators. And then I guess the last point I've already briefly mentioned is the enforcement, because there are no fixed rules where it can be relied upon. It's rather difficult or sometimes subjective. So these are the potential benefits and limitations from a legal perspective. I think they're not impossible to solve, but a lot of further research is needed to make SSbD, I guess, a legitimate concept or approach of regulation. Then briefly, also from a technical perspective, the benefits that the approach leads to active awareness on risks and sustainability in designers and innovators. And that SSbD will be assessed at an early stage and not at the end of the design process, which makes the process more efficient than if safety and sustainability were only to be assessed after the design process. Another big advantage is that innovation can be stimulated by implementing the SSbD principles. Because then there's more awareness, sciences can also be triggered to come up with alternative solutions to comply with these principles. And I'm nearly done. I see someone is unmuting themselves, probably to tell me that I need to stop. A challenge, I guess. No, can you? Yeah, a challenge is indeed is that it's rather complex to implement safety and sustainability considerations in the early stages of the product design, which can also lead to uncertainty there. And there could also be, at least in the early stages of the product or process design, little is known about the technology. So this lack of information can make it difficult to integrate the criteria in practice. And then lastly, I guess some of the criteria could also potentially conflict with each other, so that would make it difficult to find a balance between safety on the one hand and sustainability on the other. Yes, now you could please move to the conclusion. I guess the conclusion is here, and I've highlighted to it that SSbD as a regulatory approach has the potential beyond the chemical sector also in developing safer and more sustainable materials, products, and processes, and thereby aiming towards a safer and more sustainable circular economy with the EU as such, and a big step towards implementing the European Green Deal, which has also been mentioned by the previous speakers. However, there are also challenges and potential conflicts that have been illustrated, and that could potentially arise in the implementation of the SSbD approach. So this is something where more research is needed, and especially criteria and frameworks that need to be established. And I guess the recommendation is a step in the right direction. And as the previous speaker has said, yeah, now it's time to test and see what can happen. Yeah, I guess I can stop here. I have some more detailed conclusions, but I think my time is up. So maybe you have some time for 1 or 2 questions. Thank you very much.
Thank you very much, Leonie, and thank you very much for offering to take 1 or 2 questions, knowing that you have a busy agenda this afternoon. And it's with great pleasure that we take this opportunity. And I've already immediately 1 question here from Andrew Nelson, and we'll have another one here.
Hi, I really liked your talk. It's so clear and well presented, and it was just up my street, really. But
I can see and hear you very well. You can just continue. Yeah.
Oh, by the way, I noticed you were at Wageningen. I was there 31 years ago.
Yeah, my co-author is from Wageningen. Yeah.
Oh, yeah, I was there 31 years ago. Okay, so what I was going to ask was about the safe by design philosophy and the precautionary principle. So I always thought they were sort of against one another. For instance, I understood the precautionary principle that you went by the public's perception of safety, and you didn't go entirely by scientific evidence. So, for instance, if the public perceive, like, for example, sewage sludge dumping in the sea, if the public don't like it, you ban it. You don't go and monitor and see whether it's dangerous, okay? But the safe by design principle is kind of completely different, because you always operating on the basis of an evidence-based decision. So you monitor a pollutant in the sea, and if it's at a safe level, you then allow whatever the discharge is to take place. But if the level goes above a certain toxic limit set by you, scientist, you stop the discharge. So I see them as 2 sort of opposite issues, ways of dealing with the same problem. How do you relate that to what you've been saying?
Yeah, so I would say, so first of all, let's distinguish between precaution and prevention. So I think prevention indeed steps in where you, the point that you just made, when we know already the scientific evidence, and it's not about uncertainty anymore, but about likelihood of a certain damage, etc., to occur. And then prevention, the implementation of the prevention principle would mean that you implement a preventive measure, such as safety by design. And then the precautionary principle, in my understanding, starts earlier. Let's say that there's no proof of or causal link between a risk, not a danger. So under the prevention principle, it's a danger. Under the precaution principle is a risk or unknown uncertainty. And there, I guess the interpretation of the precautionary principle should be, if there's no proof, there's no reason for not acting. So it's not when in doubt, and if in doubt, act out. But if you can't establish a causal link between an activity, etc., and a necessary outcome, the precautionary principle gives you the possibility to act regardless. So in my opinion, it's not only about public perception. It's really about the management of uncertainty. So in a way, I would agree with you. SSbD or safety is more an implementation of the prevention principle. So when you already have a danger and you want to address that danger in terms of likelihoods, but especially for chemicals, for new chemicals, etc. You're more the expert in chemicals than I am. I could also see that sometimes there's a lack of a causal link, and you could still act on safety measures. I don't know whether this answered your question.
Well, it helps. I'd like to. Where are you in Rotterdam?
At the university, so I'm always happy to meet
come
up.
over and have a chat.
Yes, yes.
I like Rotterdam. Yeah.
Please do. Yeah.
I was only there a couple of months ago
Yeah.
anyway. So
Yeah.
Thank you, Andrew. Thank you.
Thank you.
The second question will be from Fred Classy.
Thank you very much for your
Thank you.
presentation. I'm trying to marry it to my fellow countryman's presentation about US tort law. My understanding is accountability for each person in the organization that develops a technology goes up with SSbD, but liability for the product in the marketplace doesn't change. Would you please address that?
I have to say that unfortunately I had to miss that presentation. I was there for the first part and not for the last one. Accountability increases and liability diminishes. Is that what you've?
Accountability of the individuals in the organization increases, but the liability for the firm's product in the marketplace stays the same.
That is an interesting observation. I wish I had been there. I would have said accountability.
I have a German background. There's a difference
Yeah.
between zuständig and verantwortlich somewhere in here. Accountable, but I wasn't responsible. So again, so the idea is that I'm more
So I
accountable.
guess one of the challenges is here that accountability should not end up in a ticking of the box exercise, which I think it's a risk that it's there. So similar to that, what we've seen now with other instruments, which shift more the accountability of the regulator to the private company, is that often with SSbD, so not the Sustainable Due Diligence Directive has a bit of a similar approach in a way that this risks of ticking the boxes and shifting the burden from the regulator to the companies. And I guess from an academic point of view, you could say that is a privatization of governance. I think I've used that term before. And this is something that needs to be addressed in the interest of everyone, the companies and also the legislator. So I think this is something that I could say for now, but it's an interesting statement. Yeah.
Thank you.
Yeah. Actually, can I ask a question as well?
Yes, indeed.
Yes, I had a question to Dr. Rauscher, who said that if I noted correctly, that the aim of SBD is to go beyond regulatory compliance, if I understood that correctly. And I was wondering whether he could develop a bit on that, because this is certainly an interesting point and one of the challenges that we've been mentioning.
Hubert, yes.
Yes, thank you. What I wanted to say is that the concept of SSbD and the recommendation, the framework goes beyond of the current regulatory compliance in a way that, for example, when you look at the framework in a little bit more detail, it makes some proposals in certain steps that certain chemicals should not be used anymore. And that, of course, it goes beyond the current regulatory compliance of a chemical. For example, when it is a PBT chemical or a PMT chemical that is can be used under certain circumstances according to the legal provisions in the region CLP, but the framework says it should not be used anymore. So it goes really beyond. Yeah. And also regarding the sustainability part, that there is not really there are not really binding legal, very few binding legal provisions regarding the sustainability part.
Yeah.
But the framework says, okay, one could do an assessment also of the SSbD and of the sustainability part, and what comes out with respect to a certain benchmark material is that one is more SSbD than the other, and that it is recommended then to use the one that is better, let's say, so to say, an SSbD. And this is not a regulatory condition currently,
No.
but so it goes beyond
Yeah.
currently. So this is what I wanted.
Yeah. Thank you very much. Yeah,
Yes,
thank you.
Are there any other questions? Seems not. Well, so thank you very much for your presentation. Oh, no, it seems there is one last question online.
Yeah.
Yes, you can go ahead. Just
Good afternoon. My name is Adrienne Sips. I'm from the RIVM in the Netherlands. And I was a bit triggered by your remark about privatizing, you call it, of governance.
Yeah.
What I often hear from policymakers, they state, well, there's a law and that says everybody who brings a product to market knows that it should be safe. And I think, but that's my personal opinion, but I would like to hear your opinion about it. Do you think this is only true, this privatizing the governance, when we talk about rule-based regulations, or do you think this is also true for the goal-based regulations, as there are also in various areas?
I think you could say that's also true for goal-based regulation, especially when we look at the corporate due diligence directive, which is now under discussion in the EU legislature, which more includes goals rather than, I guess it's a mixture. I think it's a trend that is, at least I and some scholars observe, EU policy making with regulation of processes and technologies in general. Yeah.
Okay, thank you very much.
Yeah, thank you.
So with this last question, now it's time to thank you for your presentation and making yourself available this afternoon. And we will move now to the next presentation. Will be quite short on overview of liability regimes, which I will do on my own before moving to the roundtable as scheduled in our agenda. I think it's okay. No, not yet. So this presentation will be a kind of not only recap, but also introduction to what we will discuss in the roundtable. It's about the by design approaches and liability in EU law, just to make a kind of reminder what is currently at stake, what kind of legislation we have in the European Union, and also just to go through some kind of, I would say, legislative legal history of the by design approach and the European law, which is a way to connect to what we've done in the first legal workshop more than 2 years ago. The concept of product safety, as you probably know, is currently covered, but only for a few months still by the Product Safety Directive, which dates from 2001 and which has been recently repealed by new regulation, and I will say a few words about it. But the definition of safe product exists in European law, and we have it since 2001. We have, of course, pieces of legislation which might be more specific in terms of regulations. We mentioned CLP, we mentioned REACH, but it is important to know that the concept of safe product exists, and there is an obligation for producers to place only safe products on the market. On the next slide, you will see that safety by design is somehow, I would say, in the shadow of the new product safety regulation. It has just been adopted less than a month ago, on the 10th of May, and it repeals the Product Safety Directive. So we now have a regulation. The difference is basically that member states no longer have a margin to keep differences. This is what a directive allows to the member states, to keep differences. Regulations harmonizes the law in all the member states of the European Union. And what is interesting to see in this new regulation, we have again a definition of a safe product. We have again, and we have a list of criteria which can be primarily taken into account to assess the safety of a product, including the characteristics of the product, including its design, technical feature, composition, packaging, etc., including its design. And what is even more interesting is that Article 9 of this regulation, and so there will be a lot of things to say about it because it will be applicable as from the 13th of December next year. Article 9 of this regulation requires to manufacturers that they shall ensure that the products placed on the market have been designed and manufactured in accordance with the general safety requirements laid down in the same regulation. No, we put on the same foot. This is just legal, I would say, discussion and interpretation. We use the words have been designed and manufactured. Before, we only referred to the manufacturing. No, we say have been designed and manufactured. My theory, and I think lawyers here, we will kind of play and maybe some argumentative discussion, is that I think for me, this is the way I read it, there is somehow in the shadow the question of the by design approach, which is quite logical because if we go on the next slide, we will see that the safe by design terminology has a short history in European law, but still interesting to see. The first time that the word safe by design occurred in European legislation is in one of the European Commission's communications, so which is again a non-binding legal document from 2008, and we have, and it was about the future networks and the internet, so nothing to do with materials, and advanced materials certainly not, but it was about the future safe by design. So there was the idea of by design again at the very early stage of the development of a technology. The second mention of the concept was then in a decision. So with a decision is a legally binding document. So this is a difference. And it was a decision based on the directive, which has now been replaced by the regulation, so on general product safety. And again, it says that products need to be safe by design. So this has been adopted long time before the European Commission recommendation has been adopted. But so it's interesting to see that in the legal terminology, we have seen occurrences of the safe by design approach. And indeed, as Dr. Rauscher presented, we have now the Commission recommendation. But if we just go to the next slide, we will see something you have already learned from the first legal workshop. And I think this is something specific that we've pointed in our project, is to draw comparisons between regulatory regimes which are totally different. The protection of personal data, privacy law, is something totally unrelated to the chemicals and materials. Nevertheless, we speak about regulations. And we had a very interesting presentation from Professor Rubinstein from New York University 2 years ago. Privacy by design. It's a concept that has been developed in the 70s and even more in mid-90s when we started to have computers and therefore massive processing of personal data. But it was defined from an academic perspective. And we had to wait until the adoption of the world famous GDPR, General Data Protection Regulation. You have all heard about it, at least from your employers or newspapers you try to read online, and where you have mentioned that you can no longer access because of the transfer of personal data. But the GDPR has a specific provision on privacy by design. And so it is interesting to see that in other technological areas, in other types of regulations, we have again a by design approach, which here is mandatory. This is the difference with the Commission recommendation we have now. Commission recommendation is non-binding. It's based on a voluntary scheme. The privacy by design approach, but again, that's more than 25 years after I would say the soft law approach became a mandatory obligation in regulation. So showing that if we look at the legislative history, maybe one day, 25 years from now, we have something about safe by design from a regulatory perspective. But what is much more interesting to see, it's, of course, it imposes an obligation of means, not of results. It's not an absolute requirement. And liability, if we just have a look at liability under the GDPR, when can someone be held liable for being in breach of the privacy by design principle? It's only basically if the controller has done nothing, absolutely nothing. Because we are with an obligation of means, you need to be able to demonstrate what you have done. And this is, of course, again, a methodology which is at stake. We speak about a methodology, but we have no, for the time being, we have no records. GDPR is 5 years old because it was only applicable from 25th of May 2018, but still, it is an obligation of means and not an obligation of results. So this is a way maybe to anticipate the question about liability, but we will come back to this in the round table. On the next slide, you will see that next to the regulatory environment and history of the by design approaches in European law, liability in European law, just in a nutshell, we speak here about civil liability. Don't mention here criminal liability. This is another topic for criminal lawyers. But civil liability remains mostly national in the EU. This is an area of law where the European Union has so far, because of differences and major differences between legal systems, not that much harmonized. But we have a few pieces of legislation which are quite interesting. Product liability, I will come back to this in a minute. Environmental liability, we have a directive from 2004. IP rights, we have more or less some remedies which have been harmonized in a directive also from 2004. And the famous antitrust damages, this is something specific, but still big, of course, litigation cases. Antitrust damages have been harmonized. But so we see that the European legislator is quite cautious to touch the liability issues. It's still something that remains mostly national. But interestingly, on the same day, the 28th of September last year, we have had 2 new proposals from the European Commission. As you know, the European Commission is the institution proposing new pieces of legislation. These are later adopted by the European Parliament and the Council. We have a directive on AI liability. You have heard that there is an upcoming regulation on artificial intelligence. Next to this, the European legislator has decided to harmonize rules on civil liability for AI. So this is quite interesting, a very new technology, something that is fastly moving. European legislator has decided to harmonize civil liability rules. Also, we have a new draft directive for the liability for defective products, which is due to replace the product liability directive, which is mentioned on my next slide. And so, of course, if we go to this product liability directive, which is so far a very old piece of legislation, 37 years old, even almost 38, which is quite long. If we speak about a legal text at the EU level, it's one of the oldest directives still applicable, but implemented member states. It establishes a very clear regime, like the producer's liability. This is what I said in the introduction. This is the approach. The producer, so the manufacturer, is liable. This is really the approach. This is the principle. We have a broad definition of the term product, so it includes everything movable. There was an exception, of course, for game and agricultural products. But what we have is that, of course, we have, of course, the definition of defective products. What is much more interesting and the link to the safe by design approach is what we see on the next slide. It's Article 7 of the directive, because the directive allows an exclusion from liability, and especially its point here from the Article 7. That is to say that the state of scientific and technical knowledge at the time when the product was put into circulation was not such as to enable the existence of the defect to be discovered. This is, of course, a defense which is commonly used. and it's based on the state of scientific and technical knowledge. There haven't been that many cases interpreting that requirement, but we have at least an opinion from an Advocate General at the European Union level, I mean the Court of Justice, which basically, of course, said that it, of course, what is really at stake is that, of course, it cannot lead to an absolute exclusion of liability, but of course, it must be demonstrated. So again, we go back to the idea about the methodology. What did you do exactly at the time you put a product on the market? What we see on the next slide, because this is really the state of the art from a legal perspective, is that we can come to a conclusion, and this is really the transition to the round table, is that the by design approaches, as you have seen in a few minutes, are relatively new under EU law. And so far, only the privacy by design principle became hard law, that is to say, mandatory law. This new general product safety regulation is quite interesting. I think this just mention of designed and manufactured, that's extremely interesting to see what European legislator had in mind when drafting the regulation and adopting it as such. The SSbD approach is currently pure soft law, but I think it could really revive the question of precaution taken at the design stage. And again, from a product liability perspective, this is quite interesting, even under the current regime of this old directive. I think this is a risk, depending on which side you are, or an opportunity. There are two ways to see, I would say, the impact that this SSbD approach can have. But I think what will be extremely interesting is to follow the developments for the new product liability directive, because in the current draft, but still the legislative process is ongoing, there are few mentions of the design of the products. So we see that the question of the design of the product is again something that we find in legislative text. And so it will be quite interesting to see that if there will be discrepancies between the proposal of the European Commission and the final version, because the European Parliament will put a foot, I would say, in the door, and the Council also. Typically, it's mostly the European Parliament, which usually pushes towards, I would say, some more pro-consumer approach. But here, I think it's quite interesting to see that there are things ongoing, and from a legal perspective, to see that maybe the SSbD approach has more connections than we think with current and future European legislation. This is a way to make a transition, and thank you for the attention. But it is a way to make a transition for the round table. And I will maybe just suggest that we put here the 5 chairs here so that we can use the camera to have a discussion with the audience. So I will ask, of course, Andrew, Hubert, Dalila, Ignasi to move here. So that Beatrice can use the camera to. Maybe we will take just the questions in the PowerPoint. I will sit there. Yes. We will be in an interview mode. Sorry to turn my back to the audience, but this is the best way here to. We normally would use the big auditorium, but. So thank you again, and we also welcome Dalila Antunes, who is also from Factor Social, and she's also involved in the SABYDOMA from the very beginning of the project. Thank you for also joining. We have a set of questions, and I will start with questions which are directly addressed to one of you, relying also on your area of expertise. And my first question will be, and we have here the speakers. My first question will be to Hubert Rauscher. Basically, the recommendation takes into account the principles of subsidiarity and also of proportionality. We go back really to the legal text here. Should we understand, therefore, that the recommendation somehow pave the way to further legislative action, if not at the EU level, then at the national level, as we've seen with the nanomaterials registers, which have been adopted in 4 member states? What is your opinion about this, Hubert?
Yes, and yes, it is true that the recommendation takes into account these principles of subsidiarity and also proportionality, because the recommendation, when we apply the recommendation, we have to have in view the European research area, and also we have to keep in mind the single market, the European market, and therefore the subsidiarity means in that case it is better to have an approach that is directed to the whole of Europe, to the internal market, and also and therefore yes, it's true, and the proportionality, of course, also because it takes a soft approach. It takes into account a time of testing, and it is a recommendation. There is not a hard law. So that is true, and therefore we also have to keep in mind that the recommendation explicitly is a recommendation, and it needs to be tested, and it needs to be reviewed and revised, and therefore we cannot say that for sure that it paves the way to a regulatory approach. At the moment, the Commission does not have the intention to make it legally binding. On the other hand, and if we see that when you have this example of the nanomaterials registers, in the nanomaterials case, some legislative provisions in the nanomaterials case have found their way into European regulations, such as in the REACH or in biocides regulation. It was decided at some point that this nanomaterials register doesn't need to be at the European level. But the consequence is that certain member states have developed their own registers, but they are different. So the registry in France is different than the one in Belgium, and so on. So in my point of view, this is it's a pity that these are not the same. So coming back now, I think this SSbD approach should remain a European approach, and if different member states decide to make it legally binding in their states, I would say, to formulate it like that, it would be the second best opinion. So in my opinion, it should be a European solution. At the moment, it's not foreseen that it becomes a regulatory binding. So that's what I can say at this moment.
Yeah. Thank you very much. But so it really calls the next question, and the next question is to Andrew Nelson. Next question being that as an electrochemist and inventor, of course, but you also, and you mentioned that you are scholar deeply interested and involved in the teaching and study of the philosophy and ethics of science. Andrew, do you think that the by design approach represents a paradigm shift, which would oblige scientists and particularly inventors of technologies to adapt their own practices? In other words, is there really anything new under the sun?
Actually, when I saw this question, I thought how interesting it was, because it addressed various issues that we, with my partner at home, we discussed to great length, and which also crop up in the a newspaper quite often. Personally, I think if we adopt a safety by design approach to the technology and science which we are developing, it might be kind of limiting us to some extent. And the example here is of the engineer who designs bridges. Bridges have been designed for hundreds of years, but some fall down and they don't know if they're going to fall down. And the only way that they can improve their design is by learning mistakes from the past. And it's the same with aircraft and trains and so forth. So it's very difficult it provides a lot of problems and unproductive inhibitions. If you say to an engineer or whoever that they should adapt their invention when they do it with safety by design principles, because you might find it inhibits their innovation. And the whole point of innovation, as I know from my own experience, is that you need complete freedom to operate. You need to go a bit crazy. And I've often been told I had half-baked ideas, but those ideas won prizes and many, many grants like these SABYDOMA. So I think it could be unproductive. And a further example is the new renewable technologies. We have to develop new renewable technologies, but there are going to be risks involved. But you can't say to people, you mustn't develop this technology because there are risks, because the alternative in as regards CO2 production and climate change, and even using nuclear power and all the radiation hazards, the alternative is worse. So you have to take risks, and it's like risks when you're an entrepreneur in business. You have to take those risks. And in terms of renewables, whenever there are new developments in the UK, as for example with wind technology, and in the UK we have an enormous amount of wind, as you all know, so we're ideally suited to developing wind farms. There have been environmentalists and safety people saying we shouldn't be doing this because there's a danger to wildlife, but you can't do that because every possibility for renewables has to be explored. And very recently, and I did wince at this, there was an article in it, as an electrochemist, I winced at it. There was an article in the newspaper by a comedian, actually, who I admire, but not much more, that we should stop developing batteries for electric cars. And personally, we've got to try everything. Things might not work, but we have to develop wind farms, batteries, hydrogen technologies, implicitly dangerous with the Hindenburg syndrome, and so on. But we have to explore, because if we don't explore, we'll be finished up with the internal combustion engine, which is really old technology and is highly polluting and is offensive to the public with the emissions. And so my feeling is that we should be very careful about imposing safety by design issues onto innovation. Of course, we must be concerned about safety. This is obvious, but we don't want to get too within the box, because we just won't get the innovation and we'll be ending up with the old technology. Okay, that's what I was saying. I was very interested in this.
Thank you very much, Andrew. Well, and indeed, in the European Commission recommendation, there are a lot of addresses, not only the member states. We have also the companies, the SMEs, the tech transfer offices. So there are different stakeholders, and we speak about stakeholders. I turn therefore to Dalila and Antunes, because as a social science expert and you have experience in risk studies, you've published also on this area. Do you expect that these different stakeholders, we didn't speak that much about the different stakeholders of, I would say, of the scheme, they have different interests at stake. That's quite logic. If you're a member state, you are not a company. This is quite obvious. But do you think they would be satisfied with a non-binding instrument? And I would say, calling on your experience, if you have seen that before, are there, in your opinion, any barriers which you have seen and which also have to be addressed here if they are not already addressed?
Yes, of course, this is not a perfect solution, but as Winston Churchill said, perfection is the enemy of progress. So, and if as non-binding, I would say that people that are more risk averse would not be happy, but those who are more risk prone can take a chance, so it's okay. So the good part that I see here is that, okay, on one hand, we are trying to answer the public needs and concerns. As we saw in the European survey, there are over 80% of people concerned with health risks and environmental risks from new materials and new technologies. So of course, they want to make sure that those concerns are addressed. On another hand, having this testing period, because it's what is called in the recommendations, testing period, it gives also a way to try to feel and understand the industry and the research ability to respond to these kind of frameworks, and also to understand how willing they are to put it in practice. And also, if it's a testing period, you also have time to adapt. The issue here is, are we moving towards a path of implementing a regulation or not? And that's a bit of uncertainty that that can undermine decision-making from industry to move on or not. Regarding some of the barriers, there are some issues that should be considered. I have some doubts on the implementation of the communication and disclosure. Yes, on one hand, we have fair data, but of course, that if you are an industry, if you are a public institute, yes, you should have that responsibility to make your knowledge aware to everyone working in the country, because in the end, you get public funding for that. But if you're a private industry or company, of course, you will not want to disclose your knowledge, because then it will put your competitors at the same level that you. So it hinders, of course, your possibility of success and going before into the market. So one of the strategies, business strategies, is going before into the market and feed into market before anyone else. So this is a problem. And another issue is about how much would this take? And we go to finance, because you always go to finance, of course, and the resources to do this. Because if I'm developing a project and I have to put more resources on making the evaluation of safety and making it safe, making it sustainable, then it will be probably in the end, it will be more expensive. So does it mean that we are producing inequalities. So only rich people will have access to safer products or not. So these would be some questions, and I believe that the European Commission can use this testing period and also, of course, the different countries try to understand exactly what will be the problems and the barriers that come from here, and what kind of measures we will need to put in place to reduce those barriers.
Thank you very much. And I have, of course, the last individual question is to Ignasi Gispert. Ignasi, people, of course, the biographies of all the speakers are on the website of our project. But you are a lawyer. You studied also European studies, and you are not only a lawyer, active also at an academic level, but you are also the administrator of applied nanoparticles. So you have also a business industry experience with really a double profile. And so the question is really based on your double, I would say life, professional life. How does the European Commission, according to you, fit into the legal mapping of the nanotechnology industry's activities? Or would a company like yours use the assessment framework established by the recommendation?
Let's say that from an industrial perspective, from a SME, really an spin-off like ourselves, is extremely demanding. It's extremely demanding because, as Dalila said, it's a matter of, at the end of the day, it's a matter of extra money for doing extra things that are not required by law. Our problem it's and links very much with also with what Andrew said before. You know that our scientific director, Victor Puntas, have been developed for 20 years principles of safe and sustainable design of inorganic nanoparticles. That can be done because it takes experience from 20 years of risk assessment. And you already know what principles you have to put into the design of nanoparticles for being safe, for being provisionally safe and sustainable. You will never be safety and sustainable, but you know already what design features you have to incorporate into your nanoparticles for being, as per today, safe and sustainable. So you can innovate being safe and sustainable. So there is not a limitation of innovation because you want to be safe or because you want to incorporate safety and sustainability on your nanoparticles. It's on the contrary. You have to be clever enough as to develop nanoparticles that are safe and sustainable. And it's your kind of intellectual obligation as a researcher to be able to put more values in what you are producing. So, from one side, we have that approach to the production of nanoparticles. But suddenly, we are just producers of inorganic nanoparticles, safe and sustainable. But then you get the client coming to you, and when you start explaining that methodology that you are following, or they have no interest in safety and sustainability by design because they have never heard about that, or they know that it's not legally compulsory. So they are not interested because then it will be more expensive. So then you have a kind of contradiction in the order to say, I have developed, because my scientific director has been 20 years studying that, safe and sustainable nanoparticles. But the clients are not especially interested on that. They want functionality. That is another different issue. So then let's say the logical, and you can read all the documents from the Commission saying the interest from a company point of view of being safe and sustainable, from a marketing point of view, but in real terms, you are selling more expensive nanoparticles. So that is a contradiction that you know well that we have tried to to work in the SABYDOMA project in the idea of how can you help, really help innovators that want to incorporate these kind of values in their product and having a real place in the marketplace. And it's why we came up with this idea of let's try to help them without open innovation testbeds idea. That is when you find people helping you or rewarding you because you are doing something better than the rest. That is more or less our, let's say, a difficulty in approaching the market.
Thank you very much. Now we have 3 questions and they are addressed to all of you, and I will ask you, just to save time for the question and answer session with the audience, to stick to maybe 1 minute with your answer, ideally, because that will make 12 answers in total. And so the first question is, we have covered quite extensively the liability aspect during this second legal workshop. All of you have contributed for several years to the development of the safe and sustainable by design approach from your respective fields of expertise. Has the liability dimension ever been on the radar until now in your field, in your own work? That is really the question about your own work. And Hubert, you start.
Yes, I can answer this very, very easily. This is far out of my field of expertise, so I cannot really contribute here. I think that liability has to be based on the legal framework, and I myself learned a lot here during that presentation. So this is what I can say, and yeah, it's out of my field of expertise. That's all.
Very interesting, but as a professional chemist, I did work in the laboratory for 35 years, and I have had a number of staff working for me, and we always have to take into account the safety issue, and it's become more and more stringent, as we know, and we just obey the law as best we can, so that to lessen our liability. Is that enough?
Yeah.
Well, my work is not, it's with new technologies and on both sides of industry and people. And of course, if you have people and something goes wrong, of course, they always want to know who will pay for it. Definitely. And on the industry side, you usually get insurance to solve that kind of issue. So yeah, of course, you try to avoid any kind of accidents because that's not good. It can ruin your image. But yes, in the end, if something comes up, that's ultimately an insurance issue. Yeah.
I think, yes, we have got problems in the sense that the final client that are starting to think about using nanoparticles, at the end, when they realize the regulatory landscape and the uncertainty that you are living with, they decide not to change, because it's starting to use nanoparticles in an industrial process is a real change of process. So making such huge step and that huge change of even their companies' production methods and their companies, they see very complicated. They have no intention of doing such a big jump without being sure that they will have a clear regulatory framework.
Thank you. The next question is quite much more complex, and this is why we have here the slide. We heard earlier today that the safe and sustainable by design concept could contribute to a more sustainable circular economy in the European Union. In the 6th report of 2017 of the European Environmental Agency, It was titled Circular by Design, and that was quite curious because that was the title of the document, but there was nowhere in the document where they defined what circular by design means, even for the authors of the report. But it coined the concept in European policy documents about circular by design. We have a European Parliament resolution, which was adopted 3 years later, so on the 10th of July 2020, on the chemical strategy for sustainability. And it provides, I quote here, ensuring that all uses of chemicals, materials and products are safe, sustainable and circular by design is an essential upstream measure. We started in SABYDOMA is a very good example. It's safe by design of nanomaterials. So we started a few years ago with safe by design, and we discussed about it. Even in the first legal workshop, we still use the word safe by design. And now we have later on safe and sustainable by design. But when we see that we mentioned circular by design before, this raises in fact 3 questions, but which are intrinsically related. The first one, a bit provocative, is did we forget the circular by design concept on the way? On the other way to look at the question is, should it be in fact a different regulatory concept based on another policy approach, or is in fact the circular by design concept somehow included in the safe and sustainable by design concept? And I turn immediately to Hubert from the European Commission.
Yes, thank you. No, that's very interesting. It's easy to get confused with all these concepts. I think circularity is already included in as a concept in the Green Deal and in the chemical strategy. It is, though it is not the same as safe and sustainable by design. I mean, the 2 concepts are related, but they are not the same. Meaning that, of course, one should strive towards circularity, circular economy, or circularity in the materials, in the use of materials, but it must be sustainable. Meaning that it would be, let's say, if you try to be circular under all circumstances, it may cost a lot of work. It may be much energy demanding. Let's say, to make an example, that is not sustainable. So the circularity approach could be applied within the safe and sustainable approach, but of course, keeping in mind the sustainability. Circularity is very important, for example, in certain areas. For example, I mentioned that the raw materials, the critical raw materials, they need to be, their use need to be as circular as possible because there's not so much supply. On the other hand, that circularity should also respect the principles of sustainability with all the other issues involved there. The use of energy, the use of workers, the work that is involved, the cost also that goes with it. So they should go hand in hand, and there is not a new regulatory concept necessary, but it should go hand in hand with the sustainability.
And I don't want to repeat everything Hubert said. So I'm going to speak about my experiences in the water industry, which I was talking about earlier, and also as a part-time semi-professional horticulturalist. I just think circular by design is common sense, really, and that we all strive to do it. And as an environmentalist, agriculture, for example, up to now, industrial agriculture is very wasteful and is in one direction, but can be easily designed to be circular and not only improve the environment, but also decrease carbon emissions. I mean, this is so easy to do. And also in water treatment can be designed so that it's circular. I could design a water treatment plant that's circular and that has no waste and everything's used. And I think, for example, to use coagulation chemicals in water treatment is almost such terrible waste, because it's only going unidirectional in that the chemicals are disposed of. We have to think of ways of reusing things, but I mean, I'm really saying what everybody else was saying there, but that's how I interpret circular by design. It's not rocket science.
Yes, just a few heads on. Yes, indeed, landfills are major problems nowadays. Yeah, you're producing too much waste, and you have landfills getting their capacity much faster than they should. So the need for it's an evidence of societal needs, the need for circularity. And of course, these three things are together, because if you think in a material, you need to make it safe, but also consider it's not safe for being used in a specific way, and then it goes to the garbage. No, it can be reused or whatever. And of course, you do need to assess and consider the safety also for reusing it. Can you break it? Can you not break it? The properties of the material, will they change, will not change, and all the things. So of course, I would argue, as it has been stated also in the Commission, that sustainability also includes safety, and it also includes circularity. It's just a way of making more evident that safety and circularity are principles that are on the highest level on hierarchy and should be addressed on the sustainability framework.
Yeah, I cannot reply to that. It's too complicated for me, in the sense that, for instance, I remember that in the safety innovation approach, already in the NanoReg 2 project, only theoretically they talk about safety, but it was clear and it was explained there that they considered that sustainability was included in safety. So I think that trying to delimitate too much these concepts are even dangerous sometimes. In fact, what I would say is that we need to even make it bigger and talk about including values into design. And then we can discuss with which values, because each product, and depending on each field of application, has different values that are important. Raw materials especially are especially important, the circularity value. On others, for instance, in the development of our nanoparticles, circularity, I think it's more important safety and sustainability. And circularity is extremely difficult to understand how you can recover a nanomaterial after the life cycle. So I think that it's more from a design perspective to know which values you want to or need to incorporate in your product.
And how to balance them.
Yeah, exactly. With functionality.
Yeah.
Thank you very much. And now we come to the last question, which is of course of the utmost importance for the SABYDOMA project. What do you expect in terms of outcome and contribution of the project to the current developments on the safe and sustainable by design approach? And again, I will start to the panelist who is not a member of the project.
Yeah, that's easy. Well, the SABYDOMA project was conceived some years ago, before the concept of safe and sustainable by design came into life. That was the concept of safe by design, and that project is tailored to that. And my recommendation is to stick to that, to the safe by design, and not to impose on top of that some sustainability. But why? It is not. What's my recommendation? Why? Because this, I think the project can do very, very well in this to move the safe by design approach forward. I read that you have certain case studies at different technology readiness levels. And you do this with the 4 case studies, and you can move this concept so much forward. I think it's not only nanomaterial, it's some advanced materials. I'm not sure what. So it's and that is what is lacking in the safety approach, safe by design approach. And on the other hand, by doing this, you can do also so much for the SSbD approach, because the safety is an essential part of the first 3 steps. And so implicitly concentrating on the SBD will automatically also move the SSbD concept forward. It is, in my view, not necessary, again, to top on the sustainability. What I so I expect some advance, some progress in the safety in the safety steps that are relevant for the steps 1 to 3 to the SSbD concept. And then you can say the SABYDOMA project can do also a lot for the SSbD approach, because if the project could decide to reply to that stakeholder feedback, right? That is open now and will be again open in a year or so, by giving the input of the project in that in the template. It is not necessary to fill out everything, all the questions there. What the project cannot provide, leave it empty. But from the practitioners and from the project that is on the top of the research, it would be really helpful to move the SSbD concept forward, to get feedback on the relevant parts from the SABYDOMA project. That could be something I would really good. So I do not expect this, because who am I to expect something from the project? But it would really be beneficial for this concept. Thanks.
Thank you very much, Hubert. I just completely agree with you. And what can I say? But I don't want to repeat it. But I did have the vision of SABYDOMA concept. Let's see, in 1982, walking across Dartmoor with a colleague, that's in the UK, and it was in terms of monitoring rivers and feeding back the monitoring signal to control discharge of a pollutant. And it seemed to me a very general concept. It applies to the recent COVID pandemic, and it ideally applies to SABYDOMA and also to drugs screening development. And that is the concept I would like to see fully realized in SABYDOMA, and that's been developed by these 2 guys, Will and Matt. And we hope to have that technology ready and fully transferred and demonstrated at the end of in March next year. And I think you can only make haste slowly. I don't think you should rush things in all research. If you try to rush things, you don't achieve anything. But going in steps is the way to go, and that's where I agree with Hubert. Sorry, Hubert. Yeah, we're not so Deutschland. Okay, so yeah, so get what we've planned to do fully functional and working, and like a Lego building, we can build on that model with safety and sustainability as well, because the vision I had was very global. It could be applied to anything. And in talks, when we started this, I applied it to COVID, and I applied it to river pollution and drug design. So, of course, we can incorporate sustainability. Sorry to go on.
The more the more we discuss about this and during these workshops, the more I realize this is really about decision making. And I really hope that the safety readiness levels that we are also developing can also contribute to this decision making and to balance this, because it is about balance, the functionality, the operation, the sustainability regarding environmental, socially economic and safety aspects, of course, as well.
I would say from our legal perspective, two things. One, just to put on the table the possibility of our thinking on experimental regulation in the field of nanomaterials. And the second one, to leave on the table the possibility of driving the key performance indicators from the recommendations to a standardization and harmonization.
Thank you very much. Now we have time to take questions from floor.
My name's Fred Classic. Should I?
Yeah, you can stay. If you just click the video, we can see the other participants.
For the past 10 years or so, in Europe, there has been an effort from the science and technology studies area called responsible research and innovation, which is no longer being funded. But when I listen to the group's discussion, it sounds like this is sustainable and whatever is RRI being brought into the scientific endeavor. Is that a correct interpretation?
Yes, I just wanted to reply to that because we were working a lot on responsible research and innovation, and we were extremely frustrated for the disappearance of that part. Being a little bit controversial, let's say, I have the feeling that responsible research and innovation came from not from a scientific side, and when people that are not in the scientific side try to convince the scientific people to do something responsible, I think was a kind of a wrong approach. My feeling now is that the safety and sustainability by design is coming from the technical people, from the design part, not from the philosophical part. And that makes me be a little bit more optimistic. And the only thing that I need something else, and I need that idea that it will only be a recommendation. We need something else, because if not, it will be watered down, I am afraid, not as quickly as RRI, but the same way.
Thank you.
Matt?
Yes.
I just wanted to ask a question across the board. As you were talking about safe and sustainable by design, but is that the design of the manufacturing process as such? So as such as we are doing something I thought of maybe safe and sustainable by flow. So there's continuous flow processing that has green chemistry metrics that are applied to it that is both safe and sustainable as such. Maybe not the materials, but that's another question. But are you doing safe and sustainable by design of the production or by the materials? And is there, does the lines get a bit blurred there with regards to, we're saying design, but again, is the design of the material or design of the production of the material as such?
I think that's really excellent, actually, Matt. I'm not just, saying that, but there has been a blurring throughout the discussion. And as you and as Will and yourself are you're developing technology, and do we apply the safety by design to the technology? but in reality, we are using that technology to solve the safety by design issue. And then the materials which you're producing, that's quite a different matter, you know. So we have to make it more exact, really, what we're talking about. I completely agree with you.
No, I can give a quite clear answer. It refers to three things. The design, the safe and sustainable by design, refers to the chemical and material. The first thing. The second, also the production process has to be safe and sustainable, meaning that during the production, the production process must be safe. That means the workers involved should be safe and also sustainable. So that means that the use of the resources, the energy in the production process needs to be taken into account. And it also refers to the product then that also needs to be safe. So all three components by design means the three components, the chemical, the process and the product. That in that concept, it is in that framework includes all the three steps by design.
And linking a little bit with the responsible research and innovation thing, it starts in the lab, in the design of nanoparticles in our sector, let's say. And once it starts to develop the product, it's the steps that Hubert has said. But I think that it's extremely important to understand that starts with the design of nanoparticles in the lab, because if not, all the chain it's already broken from the beginning.
Maybe we could just stick to one question per person, otherwise we won't have time. I'm sorry for this.
I want to follow up.
Yes.
Comment on that. I'll talk to you guys later.
Okay, was not just a question, it was to follow up and add, as Hubert said, yes, the chemical, the material, the product, the production process, but also the end of use process, and of course the use. Like the use has to be safe and sustainable.
Wants to answer? Who wants to answer to Dalila?
The use
not question really.
It just like a remark. Yeah, it was a remark, and I would just add that the use is important, and it crosses also with the question of the liability. And because one of the things is selling an industry, developing a product and selling it directly to the consumer. Another thing is that you're developing a product that is used in a service provided by someone else, like a medical device or something like that. So the liability becomes more diffuse and dispersed, and the responsibility so it's also harder to get.
Maybe if I can add, yes, you're completely right. It is the holistic concept, SSbD. So over the whole life cycle, from the design until the end of life, that needs to be taken into account, all the steps.
We
Just that.
yes.
The problem is that we are also talking about new materials and advanced materials. So, and you're developing one material, and usually you have a functionality and for a specific thing, but then we want to avoid it to go to disposal right after. So the thing is that where will you use it afterwards? And the thing is that at this time you cannot, even sometimes you cannot envisage what you'll do next. So it makes it harder to understand all the things. So I would argue that safety by design is a start to try to get a solution, but it's continuous, and we also need monitoring and evaluation afterwards, and to follow up all this innovation that we are having on reusing materials and so forth.
Yes, I also think that we have we can develop nanomaterials in the lab that taking care of what you mentioned, in the sense that you can tune your nanoparticles in the sense that in specific circumstances they aggregate or conglomerate and leave the state of nanoparticles as such. So you really can do that in the lab. The only that you need is to be rewarded enough as to make market value of your knowledge. That is the point for a company point of view. It's always a matter that you can do that, but who will pay for that? That is I think is that is the tricky thing. Then
we will just take the opportunity because there was a comment online from Amaya Iguatua. If you want just to raise your comment.
I think it has been already talked, the importance of considering the use phase on the design. I think is one of the phase that is less considered, and of course also to have information of the end of life use, if they should be recycling and how on, or composting, in order to inform the user about what it is should be done with the product, because we transfer once the product is produced, we transfer to the user the product, but they should be responsible for the use also of the product in the best way in order to assure durability and also to consider end of life in order to be able to recycle or to finalize on the life. But to transfer this responsibility, information should be assured in a way that should be traceable, and also for assuring the end of life or recycling, the information about the content of the material is important, the traceability, in my opinion.
Who wants to react among the panel? That will be the last intervention because we are almost behind schedule. We are past schedule.
Totally agree. I just want to make the point that, for instance, the new regulation on medical devices already established the need of traceability of the medical devices. That I think it's a very interesting development. And in that sense, all medical devices incorporating nanoparticles will have also that traceability. So I think that you are totally right, and there are regulations already starting to ask for that. And I think at the end is again the issue of soft law or hard law. If you implement that obligation, all the medical devices will be using that identification in the markets. So you are right, and there are possibilities.
That being said, we have reached the end of this second legal workshop of SABYDOMA. It was, I think, an afternoon full of intervention from experts from different fields, not only lawyers from different jurisdictions. I think this is certainly not the end of the discussion about the legal aspects and also the question about liability. Is that something at the end of the day which comes into the picture with I would say, the emergence and some kind of consecration of this concept of safe and sustainable by design. That being said, you will still hear from us, as for all of you who have registered and who have been present to this workshop, either online or here at NanoSafe, in the context of NanoSafe in Grenoble. You will receive further information. Please do not hesitate to follow us on our social media accounts, LinkedIn and Twitter. You will hear about what we are also doing here during the week in Grenoble, because the team of the project is here almost, I think all the members will be around. That's why I think it's also important to follow. And because he wants to take the microphone, I will give it to him because he's the founder of a project. Andrew, you have the last word of today.
Well, I'm not traditionally English, and they say the English are very polite, but I guess politeness it always pays dividends. And I just want to thank you, Anthony, for really organising fantastic. And I'm leading up from here.
Thank you.
Making us all feel so comfortable and at home. And I want to thank Karen and Chris. Is very good friends of mine. Karen, I've worked for 13 years. We've won 3 EU projects in a row. And Beatrice, she was the one that instigated me to write this project. Do you remember in Athens? I think it was. I want to thank them for all their help. And it really has been a fantastic afternoon. And actually, I really enjoyed the American lawyer's speech, actually. It sent me looking what torch means, you know, and now I've found one more bit of useful information. Thank you very much.
Thank you. Have a good evening.